Tonight we're talking about automobile injuries. Motor vehicle crashes are a leading cause of injury and death in our society. Everyone needs to know what their obligations and rights are when involved in a car crash. Good evening and welcome to Lawyers on the Line. I'm Sean Quinn, a partner at Falsani Balmer, Peterson Quinn, and this evening's moderator. I'm pleased to welcome our panelists, Bob Falsani, a founding partner of Falsani Balmer, and Jim Balmer, the other founding partner of Falsani Balmer. We're ready for your questions. Call locally at 218-788-2844. Or if that's long distance for you, you can call us toll free 1-877-307-8762. Before we get to our first question, I know some of you wonder why lawyers from our firm seem to be on every show, and some shows like tonight, exclusively lawyers from our firm. We thought it would be best to address this head on. Two things to know. First, some years ago, this show went off the air due to lack of sponsorship. We as a firm are committed to educating our community about legal matters, and the folks at WDSE felt Lawyers on the Line provided a great community service. So we have taken on the show's sponsorship and together with WDSE, created its content. Second, and most importantly, every year we ask literally dozens of local lawyers to suggest topics and to appear on the show during the season. We are turned down about 80 to 90% of the time. The fact is we would love to have more lawyers from different law firms appear. Over a dozen local lawyers said no to us just for tonight. All we need are lawyers willing to share their knowledge. All right, enough of the soapbox. Let's get on to tonight's show. Bob, Jim, we're going to talk about car crashes. Bob, there's a car crash, Minnesota, Wisconsin, it doesn't matter. What should the drivers do following the crash?
Well, of course, sometimes you don't have much choice. You're off in an ambulance, you know.
True.
So then maybe it's a family member that might be able to get some photos or whatever at the scene. You know, the police often in a serious case will do a very good investigation, and in a less serious case, or what seems less serious at the time, sometimes they don't have time or they think it really is not a big deal, and so they don't work it up as much. And then after that, of course, you know, the next day or two, it's time to let your insurance company know what's going on. And from there, things are going to spiral.
Okay, Jim?
I have a couple of thoughts to add to what Bob already said. First, I think we all know that the presence of cell phones makes it much easier to take photographs of the scene, of the vehicles, and so on. Second, security cameras are everywhere now. And when you're at the scene of a crash, look around and see if there's a building nearby that might be housing a security camera that could have captured the event on video. I just tried a case last week where the security camera in a parking ramp at the corner where the incident occurred made all the difference in the outcome of the case. The third thing is be seen for a checkover right away, immediately. Emergency room or your family doctor, or if you are seeing a chiropractor, be seen right away. In Minnesota, we have no faults. So if you have auto insurance on your vehicle at the time of the crash, you should have no trouble at all getting a complete and thorough checkover, and your insurance company will pay the tab.
100%.
Yeah. 100%. Yeah. It's a minor collision. Should you still call the police?
How minor?
Okay. I guess matter of degree.
Right.
Matter of degree. All right. So, Jim, guy's in a car crash. A couple weeks later, insurance company of the other driver who was at fault calls and says, well, we've decided that our guy's 80% at fault and you're only 20, and you are 20%. You didn't do anything wrong. Why can they do that?
Well, most of these things, absent serious injury, are a matter of negotiation. What they're essentially doing is offering you 80% of the damage to your vehicle. If you don't like that, you can make a counteroffer, or if you really reach an impasse, you can take them to conciliation court to get all the damages to your car paid. But you need to recognize that a judge might, as Solomon did, seek to divide the child. So unless you feel very strongly and there's a lot of money at stake, it's usually best to try to work something out with the other side if you can.
You will get the ridiculous sometimes. I mean, I had a personal situation like this where I was stopped at a stop sign waiting to pass in a vehicle. I don't know what they were thinking of. I think they were going to go into a side street or something. They crashed into the back of my vehicle.
Oh.
The adjuster called me up and said, you know, you're 10% for being there. And I said, no, I'm not. I'm a lawyer and I'm 0%.
So it helps to be an attorney in that situation.
Yeah, if you get in that car crash, go to law school right away.
Yeah. All right, Bob, we got a caller. I've had a bad back for years. Now I've been in a car accident and it's way worse. I've had more therapy, I've had injections. My doctor even says I might have to have surgery. Can I get the insurance company to pay for the driver who hit me? Can I get the insurance company to pay for that even though I had the bad back before?
Well, it's a little bifurcation there because you've got some no fault, maybe paying some bills and some of the wage loss, and then you've got the other driver's responsibility for what's going on. But realistically speaking, in terms of the claim against the other driver, your damages are what is new, what is beyond what you had before, and re-aggravation or re-injury is very tremendously common in spinal injury cases. It's very, very common.
Everyone has a pre-existing bad back.
Well, not necessarily, but you know, they do studies in, for example, where they put people through an MRI machine that don't have any symptoms. And, you know, just all kinds of crazy stuff. I mean, a 60-year-old person, if they don't have any soreness in their back, their MRI still looks terrible.
Okay, so Jim's MRI looks bad.
I know it does. I know, I mean,
Yeah.
Yeah. What do you think of that, Jim? Pre-existing injuries.
Well, I agree with everything Bob said, but I would add that if you cannot work something out with the other side and you're forced to go to trial, they will contend to the jury that a guy like me already had all these changes on his x-rays and MRI imaging, and now I want the auto carrier for the at-fault driver to pay for all of it. And jurors are very reticent to sign on to something like that. So usually you have to work pretty hard at putting together proper proof to convince the jury that you're genuinely entitled to what you're seeking.
That you are much worse.
Yeah.
just depending on the study, 70 to 90% of Americans at some time in their adult life have spinal difficulty. In other words, they've got a strain or a sprain or something happened, they fell on ice, they're vacuuming and their back hurt, whatever. And they go in and they get a few treatments, see a doctor, maybe a chiropractor, whatever, and it passes. But all of that gets unearthed when you have a case. I mean, you know, hey,
The insurance
back in
company will
1922.
get every record that you ever, doctor visit you ever had.
I see you saw this chiropractor 4 times in 1922.
Yeah.
You know, okay?
All right, Jim, the very common situation given our part of the country, I'm a Minnesota driver, but I'm in a car crash in Wisconsin. Who pays my medical expenses?
Great question. Minnesota is a no-fault jurisdiction. In other words, everybody who purchases insurance in Minnesota has automatically no-fault coverage up to $20,000 minimum medical expense, $20,000 minimum wage loss benefit. Your company will pay that regardless of the fault for the crash. That's why it's called no fault.
Unless they decide not to.
Well, then if they may decide to dig in and fight that, and then you have a whole different set of legal issues and litigation. But the policy obligates your own carrier to pay for your wage loss and your medical expense regardless of whose fault for the crash. Now, if you leave Minnesota and you're traveling in Wisconsin, which is not a no-fault jurisdiction, and you're in a crash, your carrier will still pay your doctor bills and your wage loss, and that's true in any state in the United States or Canada. Not necessarily true in Mexico unless you get a special rider on your policy.
Okay, Bob, is one better than the other, Minnesota versus Wisconsin?
Well, it's apples and oranges, of course. In Minnesota, for injuries that are not terribly serious, but may be very painful for a short period of time, you don't get anything for pain and suffering unless you have what's called a threshold with a certain amount of medical expense or disability from normal activities or a scar or whatever. But I have a case now where a guy got a fractured sternum. Okay, I mean that hurts horribly.
Oh yeah, I had
Just
one.
awful, awful, awful.
But he's going to recover.
If he happens to recover in time and not have a threshold level of medical expense, which is $4,000 excluding X-rays and MRIs and all that, and he might, because he's a tough guy, right?
Right.
He might not have a threshold because it might not result in a permanent injury or a scar or any of that stuff. So.
Well, his bills will still get paid, though, without question.
Right.
Yeah, so if you're going to sue the other driver, it's better to be in Wisconsin. If you just want your doctor bills paid and a little wage loss, better to be in Minnesota.
All right, Bob, very topical question. There are self-driving cars now. There was a thing in the news the other day about a self-driving car running over a lady and killing her. Cars have these automatic braking type things now. How's that going to affect litigation? Crystal ball stuff.
It's going to be a nightmare, okay? Because people are always going to say, well, yeah, the self-driving thingamajig was supposed to prevent this accident, so it's not my fault for running over somebody, okay? And so it's, and the trouble then is you take a case, you know, maybe you've got a $100,000 case, and you want to turn it into a products liability case over the self-driving car, and then you can spend $1 million to try and recover $100,000. You know, if you get what I mean.
Yeah.
Because Ford Motors is not going to say, oh yeah, our self-driving car is really terrible, you know.
Right. So a lot of expense just to prove a small.
The other thing is, I think it is, you know, some of these safety devices have been great. I mean, you know, you think of what's gone on in our society in terms of the safety of driving vehicles. They're so much safer.
Oh, yeah.
Seatbelt usage, all of these other things.
Airbags.
Crush, airbags. I mean, the number of people getting injured in auto collisions per collision is way, way down. And it'll be even down more because there'll be less collisions.
Right.
That reminded me of something I should have said when we were talking about the answer to the first question, which is, what do you do if you've been involved in a crash? Well, all airbag systems today are equipped with event data recorders that will record the speed your vehicle was traveling at a millisecond before the airbag deployed. So if your airbags deployed in the crash, you need to get the EDR downloaded immediately before your insurer drags the vehicle off to a salvage yard and it's lost forever.
So it's like a black box in the car.
Yeah, it's like a black box. It's like the flight data recorder on these airplanes that crash into the Indian Ocean and so on. So and whether the airbag system deploys or not, you still need to get your hands on the event data recorder to find out what, if anything, it took down when the injury occurred. So that's something you should not neglect. You should do it right away.
Good advice.
Yeah, except for this one exception to that. And that's if the injury case looks really clear in terms of liability and the police are damning one party and you're in the innocent party, right?
Yeah.
I mean, the last thing you want to do is to have the black box come out that you were going 58 and a 55.
Well, yeah. I mean, yeah.
So I just had that conversation with a client because, you know, the policeman just damned the other driver completely.
Yeah, leave it alone.
Yeah, well, and I said, you know, we could chase down this data recorder, but why?
Yeah, that's true. Yeah.
All right, Jim, a caller with a unfortunate situation. I had an accident in 2014. The insurance company offered a settlement, and I accepted it, and they paid me the money. Now it's 4 years later, and my back is way worse. Can I go back and get some more money?
Not from them, but you probably have an underinsured motorist claim.
What's that?
If your injuries resulted from the negligence of a driver who had inadequate coverage limits to fully compensate you for the harm you sustained, then you can pursue coverage on your own policy for the additional harm you sustained. And in Minnesota, you have a 6-year statute of limitations from the date of the resolution of the claim with the at-fault driver to pursue that claim. I believe the statute works the same way in Wisconsin, but it's only a 3-year statute. And in Wisconsin, I think that if you buy the insurance coverage, you automatically get the underinsured motorist coverage. But in Wisconsin, auto insurance is not mandatory. It's not required. Unlike Minnesota, where everybody who wants to license their car has to prove coverage, insurance coverage, they have a policy as a condition of getting their license.
All right. Now, it depends on how much the coverage is, right, Bob?
Yes,
The coverage that was accepted.
Right, and there's a little nuance, and that's that when the first case is settled, if you're supposed to give this sort of notice procedure to the underinsured carrier. It's called a Smith versus Clothier notice in Minnesota, and there's a name for it in Wisconsin, a case name also. But sometimes that wouldn't be done. I mean, let's say there's a $300,000 policy and it's settled for $25,000. Okay, most people aren't going to give a Smith versus Clothier notice to say, there might be a claim over the $300,000.
But it's one more thing you have to overcome.
And then there are some cases that say even if you don't give the notice, if it wouldn't have made any difference, then you can still make the claim.
Right,
Yeah.
right.
But this person has to prove that their claim is worth more than the coverage, not more than the settlement.
Right, thank you. That's accurately put, well put. And then as Bob pointed out, you can still get around the notice requirement that you notified your own underinsured motorist carrier if you can show actual notice or if you can show that it wouldn't have made any difference.
Okay. Now, Jim, obviously someone's watching our program because we got a question.
Okay.
How do you get the black box information?
Well, you have to get somebody who knows how to download it, usually a crash reconstructionist. Typically, although this could be changing almost as I speak these words, typically law enforcement people are not trained in downloading event data recorders. Typically, the average engineer is not. But there are a couple of people that live not too far from the Duluth Superior area that know how to do it. And if you want their names, I suppose you could Google it, or if you want, you could call our office and we can give you the names of the people that can do the download for you.
Okay, Bob, we got another caller. I'm going to paraphrase the question. Other driver, the at-fault driver, has no insurance. I have a deductible on my insurance, and no one's paying me my deductible back. What can I do?
Sometimes you can get some blood if you hit that stone really hard, and the blood will come spurting out, but a lot of times it doesn't come out. So if you got somebody that has no insurance and they have no assets and they have no money and so forth and so on, and you've got a deductible on your property damage of $500, say, that's normal, I mean, you probably have to eat it because you're never going to find it. You can always sue them in small claims court and hope that somehow the stone that you're trying to get this money out of wants to buy a new car and has to fix their credit.
But none of those comments apply to a bodily injury claim. If you're injured by an uninsured motorist, you can make a bodily injury claim again against your own insurer, this time for uninsured motorist coverage rather than underinsured motorist coverage. And again, everybody who buys an insurance policy in Minnesota has that coverage automatically. It's part of the policy. And I believe everybody who buys insurance in Wisconsin also has that coverage, although again, the coverage is not mandated. But if you buy it, you've got the uninsured motorist coverage.
All right, Jim, caller works for a living and was in a car crash while doing their job. Can they still make a claim? Because they're getting workers' comp benefits. Can they still make a claim against the driver who ran the red light too?
Yes. Yeah, they can. Workers' compensation benefits do not include coverage for pain and suffering. However, you are allowed to make a claim against a negligent third party who was not your employer. If somebody runs a red light and hits you. The case I tried last week I told you about with the security camera was a work injury. So my client not only collected workers' compensation benefits, but also was allowed to make a claim against the driver of the pickup truck that ran her over. So now you may have to pay some of that money back to the workers' compensation people, but you're still allowed to make a recovery for pain and suffering and loss of quality of life.
Yeah, those cases present some real opportunities for great lawyering because there are a number of ways you can settle the case, for example, and get around paybacks or allocate the recovery and so forth and so on. So you got a fastball, a curveball, and a knuckler you can throw at something like that in terms of maximizing your client's recovery, and especially if you're at a firm that does both workers' comp and personal injury like our firm where we deal with this every day.
Okay. All right, Bob. Really interesting question here. I'm a passenger in a car My husband's driving. The caller says, honestly, it was his fault, and I got hurt. Can I sue my husband?
Yes.
You get all excited. I assume that your wife has sued you several times.
No, she hasn't. No.
You could have sued her. The garage.
Why can, but you're covered by the same insurance
Yeah,
policy.
There's no intrafamilial immunity in a car accident case.
Okay.
Okay. Now, in most other guises, there is immunity in terms of the insurance policy. But in auto law, you're not allowed to have a prohibition on that claim between family members.
So if you're driving and you cross the red line or cross the center line, your wife gets hurt, your kids get hurt, they can bring claims against you. Your insurance company will cover you.
I mean, you could sue your wife for negligence for other things, but again, there would probably not be any insurance coverage. So.
Right.
Like there's a family exclusion in homeowners policies.
Yeah.
So if I'm mowing the lawn and I carelessly throw a rock and it hits one of my kids in the head, there's no coverage.
Right. The car case is different.
That's correct.
Okay. All right. Another caller. The other driver crossed the center line and we collided. His insurance company says they're not responsible because the reason he crossed the center line was he had a seizure while he was driving.
Oh. Yeah, we've had that one a bunch of times.
What's the deal with that, Bob?
There's a defense called sudden medical emergency. So when you get a defense that's raised that, boy, you know, this thing just came out of the blue, then it requires some real digging to see if it really did just come out of the blue, okay? You know, sometimes there's a prohibition on the person driving at night or driving at certain times, or they're not taking their medication, or there's a whole bunch of reasons to get around that. But if I'm driving home tonight and I've never had any heart problems whatsoever, I don't have any precursor symptoms, which again, you know, you might have, but I'm feeling just perfectly, and all of a sudden I'm stricken by a heart attack, cross over the road and kill a little old lady, my insurance company could say we're not paying. Okay. And they could win in front of a jury quite easily. Okay.
Well, Jim, same situation, except instead of a sudden medical emergency, it's a sudden automobile problem. My brakes went out.
Same thing.
Okay.
That the problem there is for us to show that the driver knew or should have known he had a problem with brakes or steering, whatever went awry and caused the injury. That a few minutes ago, you asked Bob about self-driving cars. Well, you can look through a crystal ball into the future and see the case of the guy driving the Toyota in St. Paul. And the Toyota, it's about 10 years ago, the Toyota went out of control, hit some people, and they put the guy in jail, and then they managed to convince the judge that the Toyota was defective. There was a huge lawsuit Toyota had to pay.
And he got out of jail.
He got out of jail too, yeah, that was a good thing. So, but that's a good example of what you're saying.
Okay, but so then you gotta, if you're the driver saying it was my brakes, you better have some good maintenance records, I suppose.
Oh yeah, because most of us are considered responsible for maintaining our own vehicles.
Again, we've seen both of those defenses a bunch of times.
Oh yeah.
In various guises, and you know, I can't remember a case where it actually panned out for anybody to defend on that basis, where they actually got away with it.
Well, we had one. I don't want to go into the details, but we had one where they claimed a sudden medical emergency, and we never went to trial. We settled all the claims against that driver and the driver's employer, and all of our clients got compensated. Maybe not as much as they wanted, but sufficiently.
Okay, Jim. Someone gets injured by a drunk driver. Mm-hmm. But the injured party, also had a couple of beers that day too. Who's going to be at fault there?
Well, the fact that the injured person had been drinking is not itself admissible at a trial in front of a jury. There may be other circumstances that would make it admissible.
The mere fact of drinking alone.
The mere fact of drinking alone is not itself evidence in a trial. Now, if the driver of the car who's legally at fault, if his drinking affected his ability to operate the car, yes, that comes in. The jury knows about it. It might even serve as a basis for seeking punitive damages against that driver, although it's not easy.
But if you're sitting at the stop sign and you're just blasted drunk, right, and you get rear-ended, that doesn't even come into evidence that you're blasted drunk.
Agreed.
Right.
Agreed.
Yeah.
Right. All right, we only have about a minute left, so I'll ask a real quick question. I'm injured in a car accident. What advice do you have for medical treatment?
Well, I think it's, as Jim said earlier, boy, get in and see somebody right away, at least get it documented that you got hurt, okay? Now, a lot of times the emergency room is bedlam and it's not definitive care, and you may have symptoms that come on worse the next day or 3 days later or whatever, and that's fairly common, so you may have to have follow-up and so. But I think that that is a very critical parameter.
Yeah, the people in the emergency room are only looking for fractures or serious immediate conditions. So go see your primary care healer as soon as possible. I tell a lot of people, go see a chiropractor if you trust chiropractors. And they can frequently see things that a typical MD might not believe are significant.
Okay, very good. That's all the time we have. Please join us next week when we answer your questions about estate planning. I want to thank our panelists this evening and thank you for watching. I'm Sean Quinn. Good night.